All too often, we find people using technology as a way to be able to express our individuality, escape from our monotonous routines, and most importantly, we use technology as a way to communicate. Through any computer or cell phone, a lot of personal information can be obtained. It is for this reason that Americans frequently use various forms of password protection and security software to protect the personal data stored in our devices from being obtained by an outside source. It is for this reason, as well as the President established through a plethora of court cases, that we now know how American society views the search and seizure of personal information through various forms of technology. There have been 4 major court cases that have helped to prove that the warrantless governmental intrusion onto our devices is unconstitutional. First, let's talk about the precedent established through regulations regarding the content obtained through direct interaction with the device. First is Riley v. California. Riley v. California happened in the late 2000s and basically happened when a gang member was arrested and the content of his phone was searched. The contents include images, call information, contacts, you name it. Anything and everything that was in the personal life of Riley was then now at the hands of the California police to be able to use in court. This information obtained was then used in court against Riley. And through the filing through the Supreme Court, it established that the warrantless search of a phone's contents is unconstitutional.
Secondly, we have Katz v. U.S. And Katz v. U.S. is an extremely important landmark case that occurred in 1967. The basics of the case are that the defendant, Katz, was utilizing a phone booth, which was much more common back then, and the FBI decided to bug it in order to gather his communications. No one was informed of this, Katz least of all, and Katz sued as a result because he was arrested based on the information collected. When the case went to the Supreme Court ruled against the FBI, ruling that Katz actually had a reasonable expectation of privacy. That is where we get that standard from specifically. And in the majority of opinion, it was written once this much acknowledged and once it is recognized that the Fourth Amendment protects people and not simply areas against unreasonable search and seizure, it becomes clear that the reach of the amendment cannot turn upon the presence or absence of physical intrusion into any given enclosure. The significance of this quote is manifold. Primarily, it establishes that the Fourth Amendment is designed to protect people, that is, the citizens, and by extension, their expectation of privacy that you have as a result. Not just basic locations like being outside or being inside, having various things like that.
Okay.
The significance of this quote is manifold. Firstly, it establishes that the Fourth Amendment is specifically designed to protect the people, that is, the citizens, and what they believe to be a reasonable expectation of privacy. This extends the protections vastly beyond the original intent, which was locations such as in your home or in your car or other places. It also means that the people effectively are the deciding factor, that is, the average reasonable, rational person who is used in most of these cases as a, quote, person. They are the ones who decide what counts as a Fourth Amendment privacy violation. Additionally, there was a expectation that the government could not, there was established a expectation that the government could not intrude on phone calls. So this sort of ties back into the original point in the sense that you have, even though the phone booth was in public, the government could not actually do anything about it because there's still an expectation of privacy in it.
It is the meaning of this precedent established through Katz that helped to create precedent for the court cases pertaining to not content directly obtained by technology, such as call contents or pictures stored through a phone, but rather technology collected by a third party or without physically interacting with the device. The first case in this instance is Grady v. North Carolina. In this case, which also happened in the late 2000s, Grady was arrested after being tracked through I believe it was a GPS on his ankle. The court basically established that this continuous surveillance without Grady's consent was in fact unconstitutional because it invaded his privacy without a warrant.
Secondly, we have US v. Jones, which is a similar case in the sense that it was illegal tracking. That is warrantless tracking without the consent of the individual. So this is a common theme, and in US v. Jones specifically, the FBI was tracking an individual and they placed a tracking device, a GPS, on their car. And then they used the car's location and other relevant information gathered through that GPS device to convict the man, that is Jones. Jones, of course, appealed to the Supreme Courts eventually. The Supreme Courts ruled no, you cannot do that because there is an expectation of privacy within your car and its locations, its whereabouts. You cannot track someone 24/7 all the time.
Now, this also pertains to general area, just as an additional note. Now let's talk about how these precedents established relate to the case put before us. To clarify, I would like to go into further detail about the distinction between the four court cases we discussed. All the court cases were out to prove one major point. The obtainment of most, if not any data through technology without a warrant is deemed unconstitutional. Katz v. US established the contents of a call are unconstitutional to obtain without a warrant. Riley v. California established the general contents of a phone, including pictures, are unconstitutional as well to obtain without a warrant. While Jones v. US, as well as Grady v. North Carolina, both established the key point that the continuous tracking of an individual is deemed a search and seizure and thus requires a warrant. Now, let's look at how all these precedents are associated with Carpenter.
Okay, so our big point right here is that in US v. Jones and in Grady v. North Carolina, it was established that continuously monitoring someone's location, tracking someone through GPS location without any permission or informing of the person being tracked, all of this is unconstitutional. Now, it's effectively the same case in US v. Carpenter because every phone can be tracked. Every phone in the modern world has a certain level of GPS tracking that can be initiated. There are hundreds of apps that can let you track any phone that you want to track, provided you have the correct information for that device. So phones are, for all intents and purposes, GPSs in function and form. Now, as Grady v. North Carolina and as US v. Jones both established, let's look at US v. Jones first. It is illegal to continuously put a GPS on someone and then track them without their consent. And effectively, they both prove the same point. One deals with automobiles, one does not. But because phones function as GPSs, it is unconstitutional to continuously track them as well, because you're still tracking GPSs regardless of what form it takes. They're the same form, they're the same function, and you have the same results. You have the same lack of consent on the person's part, because not being fully informed very much counts as a lack of consent. Now, as far as Katz is concerned, Katz ruled that, of course, the FBI couldn't wiretap phones, that there was an expectation, even in public places, that was attributed to cell phones. So, as far as Carpenter is concerned, Carpenter, of course, used a modern cell phone, and modern cell phones have countless features. For example, speakerphone, which is disabled by default, and ringtone and vibration systems instead of actual prominent noise systems. They have many, many features that go on to indicate that there is an expectation of privacy when using your phone, because otherwise they wouldn't have features that let you have more privacy. This is officially supported on various phone makers' websites. Apple, of course, and in the Apple v. FBI case was all about the privacy of users, where Apple fought tooth and nail in order to protect its users' privacy.
However, one question still remains. Should the duration of a search impact its validity? In the instance of Carpenter, the search was done through a procedure of tracking the general location and then only tracking the specific location for a few minutes or a few hours. The answer is clear and simple. It just simply doesn't matter. A search is still a search, no matter how you slice it. But more importantly, whether or not the official search was of Carpenter's location that lasted 5 minutes or a whole year, Carpenter was completely unaware that his phone could be used as a tracking device. It is for this reason that no matter how you slice it, the use of call data to track Carpenter's location was unconstitutional. As said in the concurring opinion in Miranda v. Arizona, as noted in the majority opinion of the justice, we, the Supreme Court, will not presume that a defendant has been effectively appraised of his rights and that his privilege against self-incrimination has been adequately safeguarded on a record that does not show that any warnings have been given or that any effective alternative have been employed, nor can a knowing and intelligent waiver of these rights be assumed on a silent record.
Okay. So the effect of the famous Miranda v. Arizona case, which of course gave us our Miranda rights that are so commonly depicted in media and in real life today. The point of this quote is that consent is crucial. It is necessary, information is necessary for consent to occur. As Miranda v. Arizona very explicitly states, if you don't inform someone of alternatives, if you don't inform them of what is going to happen within a legal context, you cannot say that they gave consent, because it's not consent if it's not informed. And this ties back to Carpenter, because Carpenter wasn't informed. He was, for all intents and purposes, completely in the dark that his phone was even used. As the Harlan Law Institute themselves have mentioned in the other question in the respondent briefs, most Americans don't even know that your phone can be used to track your location. So clearly there is a very distinct lack of knowledge that invalidates the tracking of Carpenter's phone in this case.
In conclusion, we would like to state officially and clearly that the tracking of Carpenter's phone through a third party, it doesn't even matter if it was a third party. No matter what, Carpenter's location being tracked through any instance is unconstitutional to be obtained without a warrant.
Thank you.